have a record here, and we can have Susan start talking about this before we move on.
Okay, so what we're talking about now is a very narrow thing, which is how to categorize marijuana crimes on the felony sentencing guidelines. So this discussion will not include, at least at this point, anything that is a misdemeanor or a violation, because those are not on the felony sentencing guidelines. And Rob, I'm going to trust you to weigh in on people's questions about elements and all that good stuff. Please.
I mean, my default setting
Yeah.
to treat them where they're at now.
Well, and it sort of winds up being by default, everything has to be where it's at right now because everything that changed, it looks to me, falls under 475, which is mandatory. So we just have to change the offenses. So, when the chart arrives, what we're going to do is look at crimes that had elements changed, either 3400 or 4014 or 91 or anything, and decide where to classify them. But everyone, I think, except for the two new crimes, which are brand new and do not have a classification yet, are covered by a statute 475-900 that requires things to be categorized at certain levels.
Right.
So we can go through them, and I'll show you how they're required to be categorized at certain levels. But then at the end of that, technically, the commission should vote to say, yes, we want to categorize these things as the legislature has required us to do. Unless you're going to break away and be a maverick and let legislative council come back and say,
I'd say don't waste your time.
Yeah, okay, that's fine with me.
I don't think it's
That's the,
much.
I spelled it out because there seemed to be an impression, not necessarily by the commissioners, but in the general populace, that lots is going to change on the guidelines. Not that there's been decriminalization, but on the guidelines, we're talking about the really, really bad stuff that were felonies before, and so now some of those have dropped out to be misdemeanors, but some of them have dropped down to be lower felonies, which just means that their mandatory categorization has slipped down a little bit. The two new crimes are on page 4 of your chart. The 475B 185 unlawful import or export crimes, and you got the copy that has my little handwritten notes on there, and my little handwritten notes deal with the handout that I passed around that have the actual law provisions on them if you want to look at them. So the page 2728 note means look at page 27 and 28 of your little handout, and that has 475B 185 elements on there. Basically, see what gets. The new crime of unlawful importation or exportation of marijuana in 2 different ways is a person may not import marijuana items into this state or export marijuana items from this state. That's a Class B violation, so it won't be covered here unless it is a Class C felony. It's a Class C felony if the importation or exportation is for consideration and the person who's doing the importation or exportation is licensed, or if the importation or exportation exceeds 16 ounces of usable marijuana. So the question is, where on the crime seriousness scale would the commission want to put these? We don't have any kind of guide in the crime seriousness scale currently for importation and exportation. We do have current mandatory classifications for delivery or manufacture, and it's a default to a crime category 4 if you have a delivery or manufacture that is not a commercial drug offense or otherwise mandatorily categorized.
This seems like it ought to be a little less serious of an offense than delivery or manufacturing.
Because this is one circumstance, it is an OLCC licensing. Someone who's licensed to sell retail marijuana. Taking the product and selling it out of state. Well, I guess I would that should be for sell to someone there.
One thing from here, I had favorite question about other states suing marijuana states for the export or import. I'm wondering whether it's relevant to this discussion. Is are you personally aware of those cases? And was it an individual who was liable, or was it the state or the county?
So they were all clerkly judgment actions. We filed with the 60.4 University of Portland Research. That was gone. The other one's been filed by sheriffs and district attorneys in various states. Seeking to go to the county in the state of Colorado to stop issuing licenses. I don't believe those pieces of litigation were any one of those cases. But I understand. Your question raises, however, an interesting proposition because all those pleadings basically say our citizens in North Colorado buying stuff is a federal crime in Colorado. Stop. You should stop. Under the scenario you just gave out, now people are actually selling our citizens in that same platform and arguing the same. But who knows how it's going to go. So I guess my point is that measurement, practicing measurement, and every day thought it was really important to tell all CC licensees don't sell all this stuff.
Well, I don't disagree with that. I just want to
And that's true. That's true.
But, you know, you might be able to list your license.
Couple, one, scale and scope. There's two different parallel theories, and C 60 ounces, so there could be a case for great. Second, we've got an individual who's got it's not really a business fiduciary or fall rules, so that kind of elevates it in my mind. And third, I don't know what the numbers do. So I'm thinking either we kind of lean up on getting in a number, or maybe we let the facts rise and not let.
So I'll make some more cards and maybe get some more conversations with the individuals. I believe the numbers for this one is not here. I don't think any OLCC license or mixer license will be able to get. I'd be surprised if you see only the OLCC license. I believe the second one, that's not good. There are quite a number of habits and citizens that have been enormous quantities of marijuana out of Central airports. That is important.
There's a delivery
So, you don't want that practice on airports and places where citizens. We don't need that.
And if Clinton will stand, we are bound to try to stop. That's what Clinton tells us. Hence why we have that. But what we do with that, and here's what Greg said, okay, well, for the first folks, I agree, bigger hammers. So I don't know.
So I would suggest you got arguments for not license, so no one will also just specific use.
Yeah, that's right. That's what we put it for. It's really hard to do.
Especially at this presumably one out.
Yeah, you're going to be over and off. Because you're going to have past criminal background check with the right work. Depends on how the facts play out.
It's a four.
All those that I
So Susan, this one is person, citizen, or it could be.
Could be.
Could be also, it could be anybody that is doing substantial quantity.
It's just the quantity
16 of
description.
So maybe, I was at a meeting where you kind of described it, an empty suitcase backpack, or a,
I don't want to
talk about that.
So,
So I'm curious as to the one without something around. The elements of that have to sort of be something that happened more than us. How is that not already? What's the, I'm not sure I understand.
well, because it is in certain fact patterns, it can be really there's no delivery to the person or
I forgot one.
and under my scenario, there's no intent to deliver to anyone now. There's intent to deliver 100 pounds to someone at the time. I can describe the scenario that I had a reporter here at 15 miles an hour. Yeah, and it's confidential one. No, the whole fixed. The question is, what you want to do with it? So someone is shipping. Nobody in their mind is going to import a ton of marijuana in the world. We have the best. We have the best marijuana in the world. It's the most expensive marijuana on the streets of London today. It's just the best, right? We're really talking about it. You know, and this is a key provision that we're going to argue over to try to help us close down the interstate black market, which represents within us and the black market too. So I view this as a key provision, key law enforcement tool to use, assuming we get funding and resources to actually try to close down the black market, which is another assets. Just on to going enforcement, this is happening right now, is when we stumble. Yeah, then they take it. That's big.
That's big. We go to not write it down at a later date when one gets what they're for and come back and we always revisit this because to be honest, we put a premium on it sports leash. We're gonna have marijuana for our gummies. We gotta
I'm good for the judge having long discretion here because I think the judge ought to do this something different than all systems, 200 pounds versus so Joe Schmo that's taking 20 pounds cost the border about it. I just see them fundamentally a little different. Or someone that's taking one bigger house, not ranked.
Is there a second?
there is
Further discussion? All those in favor signify by saying aye.
Aye.
Any opposed?
So then, if you want to close this out, I would move to approve those the slate of the rest and all here from the end.
Second. Further discussion? All those in favor signify by saying aye. Aye. Any opposed? They are.
Okay, well, let's do one more small step, which is the person felony, person misdemeanor. Question, as the commission looks at new and modified crimes to determine whether any of them should be personal crimes. I am doubtful that the commission will want to make any of these person crimes, but I presented it because that's part of your statutory mandate, is to look at stuff and decide whether you want to do or not. So what I did on this very last page of the handout is listed what the person felonies currently are that are listed in the rule, and what the person misdemeanor is, that is a marijuana offense or drug offense. And those were not changed by any of this legislation that we're talking about. And given that the legislation primarily reduced offenses rather than increased offenses in severity, it did not seem to me the Commission would probably want to add any new offenses for person crimes, but if there are any that you value, let me know. Or if you have any questions about this, one of them is mandatory. The 475 and 908 is a mandatory person crime. The others were discretionary. One is by causing the death of a person by delivering a scheduled or controlled substance. The other is unlawful administration of a controlled substance to the body of a person under 18.
So we're mandated. Those are already in law, or
Those are already classified as person crimes by the Commission. One of them you're mandated to have classified as a person crime, which you do, which is this 475-908, causing another to ingest a controlled substance.
Sure.
The other three, the Commission decided as a discretionary matter years ago to make them be person crimes. So by presenting this list of what currently is a person crime, I was intending for the Commission to consider whether any of the other marijuana offenses that we've heard Rob describe today, possession, delivery, manufacture, import, export, yeah, I don't think that they are, but
I would make a motion that
Up
we
to you.
don't make anything else a person crime other than the one that the legislation is
yes.
Any discussion? All those in favor, signify by saying aye.
Aye.
Opposed?
Okay. So my comprehension of the medical law is not going to be a prescription that the person gets from the physician. It's actually recommendation. And so in terms of delivering the treatments and figuring out the death of the person, is there some way doctors can find a criminal realm? The doctors really aren't going to deliver.
If they were good at providing themselves,
Okay.
They're just doing a recommendation. They're not even issuing a prescription.
No, yeah, you can either issue a prescription.
He is
So there's not really rules with doctor in the process.
well, I suppose unless the doctor becomes a licensee.
Well, now there is no doctor in Southern Oregon that actually operates a dispensary that's being practiced. Really, he's one of the top doctors.
Shot
Recommendations.
not doctor you hear.
Doesn't have a rat.
The crime is unlawfully manufacturing or delivering a controlled substance, so perhaps it's a or unlawful delivery. So Greg, just to clarify, you want to keep everything that's currently a person crime.
Yeah, but that's just.
Yeah, no, you're not supposed to remove anything. Okay. So then what I will do is take what you folks said and go back and, just like we've done in the past, I'll incorporate them into actual rule-looking things, and what you will see when I do that is some renumberings like we looked at the last time around with the 2016 cartons, and then I'll bring that back to you folks for you to do a final adoption as they are laid out, and then they will go into effect as we go.
We can do this again after the next session.
Yes!
Probably a year from now.
Yeah.
Thank you. Now, let's get to negotiated emergency victims projects. Okay. I have a handout here, and at the end of the table is Eric Zimmerman from Multnomah County District Attorney's Office. He's going to walk us through what this is. Let me give just a little bit of a tee up before we get started. This is an idea that's been around for a little bit of a while, at least a few years. I think Multnomah County has been working on this. Other partners around the state have been all the time. And so recently I was approached by Ron Arnold, the attorney of Multnomah County, and said, we have this idea for a program that exists in other states, but what we don't have is a way of funding And so he had been in a meeting with some folks from BJA, and he gave them the pitch, and they said, we don't have any grants available for that right now, but the CJC administers our federal burn jag funds for the state, and they use that money to benefit statewide law enforcement purposes. And so they recommended that he come to us and ask if we could find some money in our burn jag grant to pay for this program, which Eric, who is kind of the author of a lot of this and has been working on it for a couple of years, will dig in a little bit more. But that's kind of the background of how it comes to you. And so as Eric's describing it, it's going to be for your consideration in our upcoming burn grant proposal that we'll be working on.
Thanks, Mike. So a little history about me. I'm been a prosecutor for 12 years. Started my career in Fulton County as a domestic violence prosecutor under a WAWA grant. Definitely moved to Multnomah County 2 years later, and been there since doing domestic violence, juvenile work for the last 6 years, gang caseload, which is why I was so interested in this. It's a lot of gang homicide and homicide over there. And to testify that he said, well, how technique, 2014, probably got the biggest push. We had a pregnant woman murdered by 6 Hoopers in her house. And before they murdered her, they went in and saw this other lady thinking that was the right house. So he saw having access to resources for long-term planning. By long-term, I don't mean just while the case is pending. There's several different national models. Massachusetts has one, Florida has one, Colorado has one, and California has one. So I looked at all of them and chose kind of the meld of Colorado and California models. Colorado started in the district attorney's office in Denver and then morphed into a statewide legislative run board now, where California's always been statewide. The attorney general's office was taking funds from their archiving responder, where we have vendors pay into a fund as a fine. That's how they access their dollars. Denver has this legislative per year, and then they report back to the agencies. Here, what we would try to do is use ODA as a conduit and governing body. So all the local district attorney's offices, 36 offices would report to ODA and the utilization of funds of the agency to bank, so to speak, with a provision for each office to have any or immediate needs. So we're not having to call ODA on Saturday night at 11 o'clock and say we need this thing. Let's take it out of here to his parents' house in Kansas, because she was from this that we have some flexibility with respect to cash on hand, a small amount, and then everything else we reimbursed pretty before the Attorney Association and the body. The idea behind it would be to try and report and document everything to the extent where you're down the road fighting this work that is useful and you can see value from it. Having legislative things funding it on an annual level. California uses, so their population is people, right? They use about 5 million a year. Oregon population would be about 500,000 plus, functioning at the same level they do. Not only yet here's the problem they have, we're asking for $200,000 to start this at one time. Some all the counties have access to it within the entire state, and if useful to, I don't know, Multstop or Sebastian or the other counties. I know that Jackson County, one of the responses I got from for amendments or changes to this draft, they say we have a big problem down here. So my writing is to look at anyone else, so you don't have a problem anywhere else. California cases, the funding 77.5% are in the fiscal year 14-15 were 77.5% game related, 1.4 is all violence related, narcotics related 0.9%, organized crime 0.2%, high risk 19.9%. We don't have a definition for what their amount is. Those are kind of where the breakdown of the types of cases. Homicide, attempted homicide, 71% in California. Assault, 6.9%. Violent, 5.7%. Kidnapping, 4.9%. Rape and sexual assault, 4.3%. Threats, 2.9%. Criminal conspiracy, 1.7%. Narcotics, 0.9%. Other, 0.9%. So it's kind of the charges filed where people were utilizing the service. Community meetings, I go to a lot of community meetings within the gang culture up there, I guess, for people that are youth violence prevention meetings. And that's the one thing I hear from African American community a lot is what can you do to help people, this crisis of sort of how you can deal with community possibility by saying, after that, that it would, someone stabilize it. And Dr. Rick Harris, who is the gender DA that manages their shop, and they have a specific unit where you have a prosecution case with a lead investigator, that's the district attorney's office investigator, victim's advocate, and apart from that, you keep everything separate with your victim support program. So you have a whole other person working on the support piece, therefore making it non-discoverable in the criminal case is a completely separate case, so to speak. So we only had one instance where we had parallel information of the victim that was done in camera. It was more than just financial consequences that we received in the yeah.
How would so let's say Rainy County has a case. Walk us through what this would look like. Now this funding exists. How would they get access to it? What does that look like if they have a case? Say on Friday night.
Friday night, well, built into the program, and this is just all open for discussion on how we want to govern it. I think we'll open the discussion on how it wants to be governed. But there's 10% of what your per capita or your 1145 rate that we decided which one we're going to use. 10% of that would be held in your own shop. So the VA would have a check right away saying this is for usage of witness protection for emergency situations. Which Friday night would be an emergency. So OVA, executive director, who's managing this up. So you spend $1,500 that night. The next day or the next week, you just get a game plan with your victim's advocate. You got an advocate in your office working directly with this victim and or witness, trying to keep him safe. They would also be hopefully in touch with service providers, whether it be counseling or have access to similar agencies in other cities. If you were doing someone from Eugene, say up to Portland, whether that person in Eugene knows to call a person in Portland that does this kind of work. And then they go out and say, okay, we have counseling service here, we have daycare, health, and we need kids there, we have a HUD spot. Has access to all the services that would help make the transition hopefully smooth. And then you would reimburse that cost from the fund. So you'd be reimbursed after you pay out the fund, and then you give money back. You spend trying to make that transition. So, yeah, great measure.
And I took a brief look through here, but I'm not out of something to with Carol with roller cases. So I'm not troubled by most of the substances. I'm troubled by the violation of the competition clause aspect of this.
There's in there now not working for waiting the rather have the kids have to set up a meeting with the prosecutor and the witness and buddies well.
Well,
I think that what you're saying is valid and needs to be addressed in the other models that we do. They set up a meeting with the DA and the defense and the investigator and make that person accessible instead of trails.
I don't have a problem with that.
No, this is just basically the mechanics of how it would work as far as what is eligible for the program. There's a whole other aspect of it. Our rules still apply. Right? So,
No, I get it. I'm just, I'm not going to be able to go just find something. I'm concerned about the word
Let me ask, there's a written document here that provided with small but my understanding is what the request really is not to include all of the concept about how they're going to manage the program. The request is for us for X amount of money to be put in ADA's hands to start voting to allow so witness protection money in circumstances where the DA guard would do the mandatory and if that's the case, people would do what's information. Safe place to go. That's
great.
right.
Yeah, exactly.
So I guess there's multiple ways to do this from our point of view is to have control of the exact nature of all the details of the program. You cannot do that. But I was just stopping Mike once said earlier, the request is for X amount of money to start a program. The use of the money.
Well, the access, we could include in the CJC contract, the provision which requires that OTAs and further the transportation clause that provides access. We can provide that in our contract.
I don't think any of us would suggest that as a proposal.
If that were part of the motion to fund this subject provision drafting to address the extent that I should further thing. So that gets valid. I gotta say here, sort of nonsense.
Yeah, and so just for timeline purposes, kind of fellow commissioners, we are in the process of writing our version and grant application right now. And even for that application, I don't need to have all the details staked out for everything. Let our review at the federal government know what we're intending to use in broad strokes. And then we go ahead and execute contracts with those for funding certain things that will really get down to more details. So, and Tiffany actually, this is probably be a good time. She's done the work into what can be funded, what cannot be funded with Burn Tech. So she has a few comments on this specific proposal. Things that we would also need to include in the contract for what we can do with Burn Tech.
Yeah, so there's a couple things that we can't do as far as if they're concerned with the Burn Tech fund because there are other federal resources that provide for things such as reimbursing victims for expenses or providing wraparound services. So there's pretty much would need to be something that like 30 days would then pay for the services, pay for the emergency services of the critical nature for community directly, and then following that, they'd be able to move through the process. But we can't provide everything with this grant money because there is the VAWA and SOCA and the other crime victims money out there that is for those purposes. Because it is allowable to use it as kind of like emergency shelter, emergency transportation. So those kind of things would definitely be allowable. And I haven't had a chance to talk to Eric. I've only briefly had a chance to talk to Mike more about it. So all of that hasn't gotten back to Eric or John or anyone that's working on our project. But we do have that outlined and intend but implementation, development of the project, but this is the graphic.
All right, I have a suggestion. I don't want to cut you off for other things, but maybe one of the ways to do is at least at this stage of the proceedings, from all points of view, is simply turn this over to staff, talk with others about how to craft it in terms of what we know we would need to cover from our end, how we do this, how we want to sort out the money.
Sure.
Those kinds of things. And then we come back and make a decision on I don't know whether the timing of this requires anything more than that now.
I think, so today we want you to approve in broad strokes the money we're setting aside for these proposals. But there's no reason that we couldn't come back to you with the actual contract as we end up writing. We can review it. The money won't allow until you all are okay with those.
We want to have them.
Yeah, so there's.
We got time to work.
Yeah, so we have a lot of time before we can get the funding, and then we can bring the contract back to you all for your final approval and say so. But right now, you're just approving our applications with DJ for the funds.
And the intent was to include something about concern
Mr. Chairman, Representative Rayfield and still Senator Chip Shields on the roll. Well, Lou Frater, go ahead, involved in the process.
No, that's what happened. Just looking at California's numbers, their program's funded $5 million. Last year, they're almost $10 million. You feel the funding when you say this is what we need to keep in there annually. Last year, they only distributed $1.9 million out of the $5 million. So they still have $3 million in it. And you replenish it up to $5 million. They get us the whole thing. 1 year they spent $4.5 million. Right.
Okay, so along with Frederick process, along with Preston, and we process that contract. Again, in addition, you don't get that money itself, right? And you know.
I have another question. I see requirements for how this will be applied to the what sort of oversight is there?
Well, so you'd have to report to the fund. And this, the way we got this set up with ODAA is you would have to report to ODAA is how fill out a form and application basically, and they would be able to look at it deeply. If you're out putting your own shops on the road for money, and if they say they meet the requirements of our program, then we should be able to reimburse before that's the point. Makes sense? So there's a checks and balances system sitting in ODA. They can say, this isn't anything like what the program was drafted for. This is outside of the box. This person focus performing on the drug case, get out of town, and stick with it and help it through getting a witness. That's how they do it in both California. They report to a board, so the legislatures, the DOJ person on the board, they put the Colorado Bureau of Investigation person on the board, they put someone else with the CJ on the board, and they sit and they listen to every case. And he said that 95% of them they approve, but there are situations where they haven't approved the application, and then that the office, the DA's office, submitted.
Well, one eventual question here may be who the supervisor authority is sort of included might not be confused.
True.
Some format of multiple factors.
Yep.
But what you're suggesting, as I understand, is sort of the pilot program gets started.
That's exactly what I'm saying.
So 48A is a business corporation, non-profit, 501c4, 74 model, but they're also state agencies.
ODA.
And do that.
I know individually we're collecting
We apply for our budget.
So there's a relationship with the legislature.
So when we were talking about this in the first approach, I thought it would be.
Welcome to AT&T teleconference service. There are 1 participant on the call, including you. You are joining your conference as the host. For a menu of available commands, press *#.
Where are you there? It said 1, so you probably can call that. So, in terms of managing this fund, we, with the grants that we're managing as agency, this is not something we've gone to take on as a piece deal every time the district office wants to apply to us and piece the grant out like that. So that's why we're working with ODA. They have an executive structure already in place, and it seems like for this pilot process, it makes sense to have them report to us on how the funds are used. Of course, we have audits where we probably things like that. So that's why I think it makes sense to sit with ODA at least this first iteration, and 2 years from now when we go to the legislature. It could very well make sense to be the DOJ, Services Division, or even some other entities to control these funds. But from our perspective, to get this started, that's why I encourage to do that.
California Attorney General's Office oversees every state has the same Massachusetts. For the pilot.
Other questions, comments, Gary? You have more?
No, this is just a draft that we're working on, and it's still working at the Army here in Oregon.
So we'll maybe take them all at the end when we discuss the total burn jag application.
Oh, sure. Yeah.
Because up next is DOC.
On the slide here, yes. I'll switch it. Okay. Good afternoon. I'm Jeremiah Strawberg. I'm Assistant Director of the Department of Corrections. I oversee the Community Corrections Division for the agency. And what I have for you this afternoon is also a request. We've got about 10 copies. Our request is relates to GEN funding to support the development of what's being called the Victims Information Portal. So a brief history. First, you're receiving really a copy of my talking points here, as well as some information about a grant, the collaboration between local county and the state. What this is back in November of 2014, a number of state agencies, the Parole Board, DOJ, DOC, met with a number of counties as well from across the state with NIC technical assistance to map out our victim services. And really, where are the gaps for victims as it relates to the criminal justice system? And what we were able to determine is that the most significant gap was victims' access to timely, accurate information as the case moves from prosecution, sentencing, incarceration, supervision. Each of those entities I just spoke of have their own victim services, limited access to only the information typically within that particular office. This causes great confusion, misinformation being shared about what's going to happen in the next part of the system as an inmate or offender goes through the system. A lot of redundancy as well. And what we looked at is we wanted to develop within the state a more seamless model of information where victims would have immediate access and understand where the individual is at in the criminal justice system, what is available to them and their rights as far as meaningful participation in hearings, in changes of events. What did it mean when they were getting notifications through the line system that an inmate was moved or in custody or out of custody? What's the difference between probation, parole, post-prison supervision, early release, early termination, early discharge, whatever concept or issue the defendant may be faced with, and involved in the system. And so creating one place where there would be accurate shared information for victim services was the goal. There were some states that are doing this very well. Minnesota is an example. So District Attorney Rod Underhill, members of the parole board, victims attorneys, and DOC, some representatives from our agency, all went to Minnesota to look at their model and that this comprehensive information technology system they have for sharing information that victims were entitled to. We came back, started talking about how can we do that here in Oregon, and of course, like any big IT infrastructure, it's about time and money and energy. We discovered, bridging to the second page, a nonprofit agency called Code for America. Code for America is basically where you get engineers, designers, and researchers from Silicon Valley who are willing to go on sabbatical from their current agencies to do goodwill work for governments. And they are willing to come in and do what we as state and county government are unable to do, and that is quickly and efficiently build an IT infrastructure system that's sustainable and provides you with all the latest bells and whistles and across multiple platforms.
What were they for the health plan?
I wasn't going to comment on that. But as you'll see,
These guys are all half from Oregon, right?
even from the document that I provided you, what we would be receiving through this grant is 2 to 3 researchers and IT developers from Google, Apple, Facebook, Amazon, Yahoo, who are willing to take a sabbatical from their work, come to Oregon for 6 to 12 months, and work with us directly to build a sustainable platform for the exact work we need. It's a $500,000 package, of which the state is responsible to provide $250,000 in cash. Multnomah County has agreed to be the pilot site and to invest $150,000 into the program. What we would like to do from the state level is invest $100,000 of the $250,000 into this program so that we can see it beyond Multnomah County and truly build a platform so that we design that all those systems eventually will be able to participate. And so my request to you today is to consider $100,000 in funding to support the development of this platform so that we can have significant influence in the state wide. With that,
this is an incredible opportunity for us to do this. I was really excited when Jeremiah brought the project into the opportunity to weigh in on this. This will be really cool to see one point of contact for a victim throughout the entire case. Would be a good thing. Yeah, especially also aligned with our investments, with justice reinvestment. Such an expansion at a local level in most programs. So that re-entry, we're involving victims in re-entry now, so all this.
Well, my experience of it is probably a single roughest point of contact for any citizens having in the criminal justice system, which on serious cases, are victims' lack of connection to the system, to know what's going on, to feel that they're very out by the system once the system runs through its due process, of course. If the person goes to prison, it's difficult for them to stay engaged and feel like they're part of having any say whatsoever.
Specifically along those lines, the system would allow you to immediately know who's the DA involved in this case, who's the probation officer, who's the prison counselor, what are all contact information and access so you can gain additional relationship information that's needed so you can help them understand that.
Okay, I'm sorry. I've heard some discussion from victims advocates around the early termination of probation. That once the case was
Yeah, so I'm going to turn this over to Paul and Tiffany. If you want to reference this piece of paper right here, it's titled FY16 Edward Burn Jag Application Highlights. And this will be the action item for you as commissioners as we walk through the entire, what we're intending the entire application to look like. I'll just mention, because we've brought to you before the LIPSIC grant that we're applying for Maximizing Justice Reinvestment Initiative, which is to staff LIPSICs across the state. And Madeline's here, she's taking the lead on that project. But essentially, we were able to work with and select 10 counties who we could give each a half-time professional LIPSIC staff so they could continue the work they're doing on justice reinvestment and the work that is necessary with the LIPSICs to kind of really dig in and map those systems and things like that. You'll see when we get through this document that we're intending to allocate a large share, about half of our Burn Jag funds for that project, which is really intended if we don't end up getting the Maximizing Justice Reinvestment grant from BJA, we would still be able to move forward with that program and even do maybe a few additional counties. Of course, that's a 3-year grant, so we have to work it out, but that's why we're kind of applying for it in a different grant and setting aside some money within this application so that we can at least do that to some extent, because we really feel as staff that working with LIPSICs has been a critical part of us implementing justice reinvestment to make that work. So that's just a little background on that. But with that, I'll turn it over to Paul and Tiffany to kind of just walk us through a little bit of the Burn Jag background before we vote.
I'm listed on the agenda, but Tiffany's going to present the Jag on
Yeah, so if you want to pull up your highlights page that Mike referenced, our total award this year was $2,080,050 at the top, which is a 6% increase from what we received last year. So we were excited about that. So it's just a little bit more opportunity to stretch a little bit further. The very top part where it talks about the JAG funding and the areas that we can use it for, those are just the categories that any type of funding sources have to be put into. So for most of you, I think this is not a new thing, but for those people that are newer or aren't familiar with the process, that's what those are. We've chosen to work with 3 different topic areas. The first one listed is the drug treatment enforcement programs. That will continue to help us fund our specialty parts. We do receive general fund allocation and limitation for that. So that's what we use to primarily fund operational grants. But we receive other requests often for different evidence-based practices to help either boost the grants that we're offering as operational grants for other practices that would otherwise not be funded at the baseline rate that we offer, or for additional training and things such as that. So that's kind of what we use this money for. We're planning to allocate close to $600,000 on here. I know that this number is a little bit higher than that, but we may make some adjustments to that. We'll explain a little bit later. The second category is the planning, evaluation, and technology improvements. Like Mike kind of threw up for us, that's for the Maximizing LIPSIC grant that we've already talked about, except for the other thing that I would add to what he's already said is that if we don't receive that grant, yes, we can use this money then. But we also have had a lot of requests outside of the counties that are listed in the grant. I believe there's 5 other counties that have expressed interest for staff. So we really could serve half of the 2/3 of the state with this money to supplement the other grant should have come to us. We can do some really great things and hopefully get that to a place where the counties will realize the usefulness of these staff. This is now been presented in the last meeting, and then be able to continue funding that going forward, which really helps our justice reinvestment efforts and helps our public safety system and the entire thing.
Just as a reminder, we're partnering with AOC on that grant, so they're going to help us do the administration with the counties to get things done.
long as you did work with legal on trial. And I will see.
we've heard from both of Jeremiah and Eric about those two programs. The one being I've called it here the Crime for Victims Emergency Assistance Fund. I planned this before I had to witness the WISP program outline that you all have in front of you. So it would be strictly for emergency services, critical, immediate, those kind of things for crime victims, which in this case would also be witnesses. So I'm certainly familiar with this. And then the victim services portal, which is guiding all of our public safety systems so that the victims can follow through the entire process and not have what they need to know get lost somehow. We could complicated system. The one thing that we would ask you to change, as I understand, is allocating $200,000 to the emergency assistance fund, which is what Eric has asked for. That's not printed on this paper here, so that would bring the crime victim section to $300,000, and the drug treatment and enforcement programs down to $572,000. So that's how that would shift.
So initially when I got the write-up of this program from Multnomah County VA, it was $100,000 in there. So Tiffany and I worked off of that, and then working with them, that was an error. They had to request $200,000. As you heard from Eric, that's still not even half of what California would be funding this program. It gives us some flexibility funding it for $200,000 in this year. If it's not all used, it doesn't go away. There are 4 years to spend this money, so they would be able to just continue to work off of that $200,000. Conversely, if they did go all the way through it, they could always come back and ask us if we could help them anymore with drug jag. But also, we really don't know what this is going to look like and how much use it's going to get. There'll be an education period getting it out to the district attorneys to understand what's available. So it's, we're kind of a little bit taking a shot in the dark, but funding it at less than half of what California states there is at. It seemed like a good way to start a pilot. So that would have been that, like we said, at $300,000, the drug treatment enforcement would be $100,000 less to get to the total of $15 million. You also have in your packet this spreadsheet of JAG program obligations. Just historically, multiple of you have been on this commission for years, so this is familiar, some of you are new. But I thought it might be instructive for you to see what we've funded in the past. And really, the theme that we have pursued has kind of been, we have to go through the lens that Tiffany laid out in that document of being statewide and benefiting law enforcement statewide. But also, we traditionally use these funds to start innovative programs and give them a chance when we see a good idea to get them off the ground, with the hopes that this is not going to be the sustainable funding source for any of these programs, but that we can get things kick-started so that if it works and it's a good idea, it can be picked up by the legislature or other options. So you'll see that this proposal is in keeping with years past in that. But I wanted you to have this just so you can see historically what we've used JAG funds for in the past. And then Tiffany I wanted Tiffany to talk about sanctuary cities briefly. You have a paper here called Sanctuary Cities, and something new happened in our JAG application this year in terms of the language that they use, and we just want to tee this up for you as a potential issue down the road.
So as you can see at the top of within the double lines, the language that's highlighted there, that's being reversed to the solicitation this year. So it talks about, it comes out specifically, I guess, the law that speaks to sanctuary cities. In Congress, you have in Ohio a law that sanctuary counties, and I believe cities also, but this was the aesthetic defining and how that references out in our state. I believe about 30 counties are sanctuary. This is not saying.
I disagree with all of that.
Well, there's an ordinance statute.
There's a
statute about not being able to share with us information that's disqualified for it.
But it doesn't say that either. So the problem is that all these counties, how they say this, Wilmot, Honor House, and Cleaner, that's because in Oregon, if any county honors an ICE team, the doesn't have any other basis to hold someone, the federal courts in Oregon and Massachusetts is paying a lot of money for such an activity. We need to all stop clapping the fires. And they paid close to $250,000 for 15 days, someone spent in jail on So I'm trying to agree with the magistrate's decision. So ICE containers are problematic. ICE holds if they go through the court or not. So I wouldn't characterize any of our counties or cities as sanctuaries, because those are cities or counties that intentionally say, we're not going to work with INS. Our counties work with INS. We provide information, they provide us information, but we reject their ICE holds. And if they meeting at the U.S. Attorney's Office last year about that, and like, they don't have all the cards are available. The bottom line is we can't honor your ICE holds. We just can't. We have to offer a different mechanism for us to hold people. Otherwise, we right to get check.
So it's if you're in any other state.
It's not, it isn't just that, keep in mind that the federal law, and I read the federal law, sorry to take over this conversation, this is a high issue last year. I read the federal law differently than certain people of the U.S. Department of Justice. Not all of them. Because the federal law basically says, you shall not place impediments on the sharing of information with INS, or whatever it's called today, forget what. ICE. You shall not share information back. You cannot place impediments. Our statute says we will not do the enforcement, and it has specific exceptions to the information. So I believe our statute, which is now, it's not in 181 by the way, federal law, that's in 181A. I believe our statute fully complies with this statute. Right? And I think that's what we should tell them to ask. And we should also provide them with a copy of the federal district court case that says, if we do other than what's listed here, we're getting sued and we pay a lot of money. We will do that. Okay, sorry. Just obviously, we ramped up big time on this last year. I've got a lot of emotion.
So this has been flagged for us, and this is how we are listed. Tiffany pulled this list off the federal website. This is how we are listed on their website. They have not come to us and said that we are definitely going to withhold your burn funds, but this is new language that's suddenly in the burn application, and we are listed as a state that is full of sanctuary counties and cities.
I don't know why they do that. I've had two defenses. One, our statute doesn't violate federal law. And number two is we have a district court opinion that we're all bound by.
So luckily we have Rob Levette as commissioner, and when they call us, we're going to call
Rob. Freaking that. So you know what? It's your federal judge that is making my members pay out big bucks if you honor your ICE detainers. You deal with the Fourth Amendment, not me.
So that's just
For your information.
Yeah, sorry.
I'm
sorry. Yeah, you hit a hot point there.
We should pay attention to this.
Right.
We should pay attention to this. This goes all the way back to DC, and there's politics behind this.
Yes.
And there's bills on confidence. They're still open while they're not taking any action on them right now. There are bills open during this session.
Depending on what happens in November, this could look like the weakest cheese ever.
Yes. It could.
So this language is all very descriptive that we've written in here. Every email correspondence that we received about it is also very descriptive, and they don't say they're going to do anything. But I just wanted to bring it to people's attention. I brought it to Mike's attention, and she asked me to bring it to
Well, if you need the dad cop on the phone call, I'm the person. As exactly.
Totally clear.
So that we can answer any questions about the proposed allocations in this fiscal year JAG.
I have one.
Yeah.
What does it do to drug treatment enforcement programs to shift those outside of
Yeah, so you'll see what we funded last time. We didn't actually use this money in our last application for drug courts. But we did in the JAG year before that, 2014.
where do you see this?
So looking at the this one here that says we'll use the JED application form 15.
So 411,890 you still haven't used.
That's right.
You still have it.
Yes.
And this is an increase over that, even though it's a decrease from what we were.
So maybe, Paul, this might be a good spot for you to jump in terms of what we still have, because we have 4 years to spend this money when we put it into this grant application. So some of this we haven't spent even from previous JED applications.
That's correct. So we still, we use this to essentially shore up the general fund program, because we usually have applications and requests that exceed what the general fund amount is. So this is what we use to really take everyone that receives warranty in the vetted application awarded. So we do pull from multiple years. You'll see that reduced amount in the 2015 was split between special enforcement and PCMS. We need to upgrade the information system. So we took what we normally would set aside for that and reduced what we would need for operations. They're called targeted needs grants, the handout we have for you, but it also goes to operational needs. So it's not exclusively targeted needs. I don't know what else I should comment on this, but we can show what the balance is. There is dollars remaining, and we need to use those into contracts, and we find out that
So essentially, we're going to go into this budgeting cycle. We're going to ask for a current service level or something, which would basically give us keep funding, especially most of the funding. So taking $100,000 out of what our previously proposed budget will not shut down any existing special enforcement. That money is not already earmarked for some sort of it's to give us that ability to augment or look at new applications or to supplement things like training and things like that to help workforce maximize their effectiveness.
we don't use all the money on the website, that'll fund for special enforcement.
Yeah, really cool already. So in terms of the listing program, who's anyone that part of that?
Jackson County, Madam.
Sure. So just inquiry was not explicitly included in the but just even to listeners that huge version of this is a big
So it's not contact with the county, but
Is fortunately, I mean, it just might, it's all good.
No, but he's looking for.
Yeah, that's right. Okay, well, that's on the floor. There's one more quick question on that, on the listing. Totally support listings and investigations and how to know that for DRRs taking the ground running. You mentioned the usefulness. Is there a kind of a longer term plan to create these counties a sustainable pathway there and carrying that role, recognizing the value of their listings and investing county dollars and doing that like other counties have done?
That is like the same thing with funding the victims assistance program that Eric described. This would be the pilot to kickstart them. If we did the BJA Maximizing Grant, that lasts for 3 years for us to fund those 10 counties. And so after that 3 years, we got approval from the legislature to apply for that grant, and they made it very explicit that we have to even the kinds of this is not ongoing funding, this is for 3 years. So the idea is to give them a chance to get off the ground, see the value, and then either try to figure out the fund themselves or through the legislature. But it would not be continuing to come out of jail.
I would move approval of all the firms that proposals that we can just rid of us. And that would include the notion of concerns about competition clause about this program incorporated into that contract. I'm sorry.
Alright. Any opposed? I have to be a state. So the conflict is
this particular section. Okay, Ross.
I'll be quick so we're on. So we've been hearing from a handful of counties. There's a little bit of confusion around the OAR that's certain kinds of sanction units. Mostly it's to do with jail sanction units, but just how many sanction units are authorized under those two OAR. They're a little bit confusing. They reference each other and kind of go on a loop sometimes. This is also coming from context. It's mostly closely supervised probation. We're using a lot of short sanctions, and sometimes they're holding people in jail, release early to treatment and stuff like that. So it's come up with a handful of counties. In some cases, it's been the POs, other cases, it's been some of the DEAs and judges have asked us to look into it. So what we were thinking, and what Mike and I talked about, and as well as advice from communicating one or two of you to take a look at this, we had been creating more detail about what the concerns have been, and clean up a little bit. The idea would be to change the rules in any way or change the amount of sanctions, but just to maybe clarify them a little bit. Maybe at the next session or something. Volunteers.
I mean, at the judge's request, I took a little bit of the OAR to stand. I think that how they're written is complicated because what the law reflects. I looked at it in some detail more than a couple of times as to where I thought things could be streamlined, and I just don't see it. I don't see it as a writing problem. I see it as a complicated law problem. So I'm not sure, without more information about what specifically understanding we can use. Simple, really, right?
Yeah, that's another thing that came up is that in some courts people are waiving their limit on the jail custody and spending more time. I think they use it in the context of staying, revocation and staying in jail until a treatment bed opens up. So that's kind of happening in special court a little bit. So I didn't think that we should, make any rules that very complicated. If you want to, that seems like it's up to with that, but it's kind of a couple of these political problems. We've heard about it from various counties all around the same time, so I just wanted to bring to your attention. Maybe it over, maybe we will over time.
So I think, and I appreciate what Greg saying, that maybe this is just a 3-year statute, and that's what we have to do, it's complicated, and that's what it is. But I think investigating that, making sure that that is, that we're doing what we can do as a commission. And it could be that after undertaking that, we might come up with some statutory suggestions to make things better. I think we're getting enough questions from multiple places around the state of lawyers calling us asking, what does this mean? This judge is interpreting it this way, can we do that? That it's complicated. And so I think it would be great if a group of us as commissioners were willing to take this on as a project and look at it and just make sure that we're doing what we can do as a commission to be clear in our rules, and then maybe there's some statutory suggestions, or maybe there's not.
How about this? I'll talk with Mike about this. Maybe call some people who like in the city and maybe figure out whether or not there is a problem. First of all, if there was a problem, let's figure out what they are. Whether or not school hours are problematic, if there's a problem or not. For my part, Department, it's not smart.
Who's that? Oh, it's
Well, here's what I'm thinking is we can talk about what entities ought to be represented in a discussion about this and see if we can flesh out whether there is a problem. Successfully. And if there's a uniformity problem, there's a real problem county to county or whatever, maybe it's something we can just adopt otherwise. That's going to be, I think it's fine. So I'll talk to you in a very quick.
All right. So the final agenda item, I won't take much time. Thank you. That is too bad because it's really cool. And thank you for commissioners who have looked at our Justice Reinvestment dashboards. They are live on our website. They allow you to see the entire amount of money that the legislature invested into our Justice Reinvestment grants, how that's broken down by content area. So, for example, the programs versus the victims funding versus the 3%. Courtney, who's not in the room right now, has done yeoman's work on putting together these dashboards. I think that the legislature is going to be blown away when they see the transparency in the way that you can tell immediately every county how they elected to spend those funds. And then at the same time, we're just beginning to track outcomes that we're asking for information from the counties. So, for example, how many people you assess to need treatment, how many people are currently receiving treatment, how many people have completed treatment. You can see that broken down county by county when it's paid for by Justice Reinvestment funds. So if you haven't gone on our website yet and checked those out, please do give us feedback. We have not done a formal public announcement. We kind of soft shot it out to our stakeholders and commissioners for feedback, but it is on our website and it is live. It's really, really cool, and I think it's really setting the bar for transparency and grant management.
Well, I gotta ask you, do you know about this? Do you know up on this at all? Yeah.
This would be a great resource.
Yeah, it really would be. And you would be a great resource for us as well to have more of the public know that there are things happening that give them access to a lot of information. That they can just go on a website. There's all kinds of comparisons between different entities, between different counties, a myriad of subjects. And this is phase 1.2,
Yeah.
sort of, but there's other things that are post-education and adoption. Those will come on later as well. But this is one that's really matched up with this. So we really spend some time on this stuff.
So the next thing you'll see is our recidivism dashboards. You all are aware that we have worked with DOC and other partners, OAG, and OSP to be reporting on the new definition of recidivism in Oregon since 2013, which is arrest, conviction, incarceration. And we put out 3 reports now. In this last report, we noted in bold that from now on, instead of publishing 15, 60 reports, it's all going to be online in the dashboard, and so that you can go county by county and immediately compare where the citizen is on all the ordinance, to the state laws, to the region. You can cut it by gender, you can cut it by risk level, you can cut it by race and ethnicity. It's really going to be, right now we're rolling out with human corrections directors so we get feedback and data mining and make sure everything looks good. But we anticipate having that up on our website mid-July as well. So we'll send you all out so you can start to play with that and give us feedback as well. But we're really excited for the outcome. We've got some other dashboards in the work. We've already got our prison usage dashboard up. So we're just really doing some exciting things. Like we just said, we're not aware of staff of any other entity in the country doing this kind of work. So I'm excited about this target to speak in Philadelphia this summer on the work that we're doing on this and the work in our thing. There's a lot of interest in the work that we're doing here in terms of getting information out, transparency to the public as well as the stakeholders for the city. So happy to sit down with any of you and walk you through these things, but I just want to put that in your ears so you'll be looking for them and
Really impressive. Okay, anything else for the good of the order here? All right, thank you for coming, everyone.
I think.